Good day to you. My name is Tom Swanson, and I'm here to talk to you about a weird case. This is Law of the Weird, where I bring to your attention appeal court cases in which the background or circumstances is, in my view, extremely weird. Today's case, I've kind of nicknamed it as the absolute De-Lux ass kicking. Okay. This it arises out of a case that's entitled, Wheaton Van Lines Inc. versus Mason. And this case was a Court of Appeals case out of Fort Worth. So it's a Texas State Appeals Court case that was decided in 1996. Okay. Here are the facts, all of which are somewhat strange. Mr. Mason decides to move from one apartment within an apartment complex to another apartment in an apartment complex. Now, most of the people I know, if they were going to make a move like that, they'd probably get some buddies together, a couple of six packs of beer, and they would all help the guy move from one apartment to another. Not Mr. Mason. I don't know what the circumstances are, whether he was just very cautious or had no friends, but he hired a moving company to do this move within the apartment complex. Now, according to Mr. Mason, he wanted to use a moving company with a good reputation, and he looked in the yellow pages and saw an advertisement for Wheaton Van Lines Inc., a prominent ad in the Yellow Pages. And apparently this had been placed in the Yellow Pages by a local agent, David Lux, DBA, Absolute De-Lux Movers. Okay. So at any rate, according to Mr. Mason, he was relying on the reputation of the moving company. What Mr. Mason did not know, apparently, was that the Wheaton Van Lines Inc. was an interstate mover. I'm going to tell you that the moving industry is a bit weird in and of itself. They have all kinds of rules because you have interstate regulations, and some movers can only do interstate moves. And what they do is they often operate through local agents. Okay, the Absolute De-Lux moving company, the local company, was available to do moves for Wheaton that were interstate only. So if Wheaton had an interstate move, out of Texas, it could contact Absolute De-Lux and they would handle it. According to Absolute De-Lux, they only handled a few of these a year for Wheaton Van Lines. At any rate, it is fairly clear from the case that Mr. Mason there was nothing that led him to believe anything other than that this was part of Wheaton Van Lines, and that he could rely on that, when such was really not the case. Absolute De-Lux movers had two moving people, two employees that conducted the Mason move. One was named Pritchett, the other was named Mullinax. Okay, now the unknown to Mason, Absolute De-Lux did not do background checks on its employees, which I find pretty incredible. I mean, the whole issue of theft and all these kinds of things, you would obviously want to background check someone who was doing moving. But Absolute De-Lux did not do this. Had they done so, they would have been aware that Mullinax had multiple charges for illegal drugs, and had also convictions for burglary, and strong arm robbery. Okay, so what they had was they had a pretty bad dude there working for the moving company, and apparently the owner claimed he didn't know. At any rate, the move was done, and thereafter Mason made a complaint to Absolute Deluxe Movers that he was missing a box of compact discs, and that he wanted something done about it. Now, interestingly enough, from after the move was conducted, Mason's move was conducted, and in the time of the complaint from Mason, Mullinax ended up in jail for some reason. Mullinax contacted the employer from jail saying, can I send my wife by or whatever to pick up my check? I'm in jail. At any rate, the issue of the missing compact disc came up, and the owner of Absolute Deluxe Movers fired Mullinax for what he believed to have been theft of these compact discs. Okay, you with me so far? Good. Now here's where the fun begins. About a week after he was fired, Mullinax confronts Mason and gives him an absolute serious bad ass whipping. Okay, I mean beats the crap out of him, cuts him up, breaks bones, causes a skull fracture. I mean, really beats the living crap out of this customer. Okay, so as you might imagine, guess what? It's lawsuit time. Okay, in this particular instance, Mason sued Absolute Deluxe and sued Wheaton Van Lines. Okay, the case went to a jury trial. Okay. And both of the parties, both of the defendants, Absolute Deluxe Movers and Wheaton Van Lines Inc., were both found liable by the jury. The claims were twofold. One was violation of consumer laws in Texas, where if you cause confusion as to the to the consumer, if you legitimately cause them confusion as to the uses, benefits, ingredients, etc., of goods or services, that's a violation of the Texas Deceptive Trade Practices Consumer Protection Act. So there was that suit. And then there was the suit for negligence. And of course, you know what this is about. What are you doing hiring this criminal, to be doing this move for this guy? Okay. It's interesting to note that the other side the defendants made no comment about the fact about what is this deal about using a moving company, to move within the same complex. Well, I don't know what to make of that. I'm not going to say anything more about it. It's just, certainly you'd think someone would have enough friends to be able to get that move done without having to call Absolute Deluxe and getting your absolute ass whipped. Okay. Bottom line is the jury awarded about $1.3 million. Okay. And Absolute Deluxe did not appeal, but Wheaton Van Lines did. Okay. Now we get into some areas of law that are kind of, I don't know, they're kind of murky to some degree. And they also seem in a way kind of unfair. It just depends on your vantage point. But basically, let me tell you some basic rules of personal injury law. One is usually an employer is not liable for the criminal acts of employees. Okay. So the notion is the employer intends to do lawful business and engage in lawful conduct with respect to customers. Okay. And so if an employee does something like assaults a customer or something like this, if the nature of the work would not bring assault into play, in other words, the person's not a security guard, they're not a bouncer at a nightclub, that sort of thing, then if they assault a customer, it's not in the course and scope of employment. Hence, there is no automatic liability under respondeat superior, the normal rule that says that an employer can be held liable for the negligent conduct of an employee. This conduct was not negligent. It was criminal, intentional misconduct. And so it fails the respondeat superior test. There's no doubt about that, okay? Ass whippings, if you're not a security guard or bouncer, do not constitute course and scope of employment. But there's other issues, such as, negligent hiring, negligent supervision, things like this. In other words, if you've got someone and that person, I mean, how hard is it to do a criminal background check these days, or even back then? Okay, you've got someone that's going to be handling other people's property. Okay, you'd want to do a background check on them. Now they probably do drug testing and everything else. But the point is that Lux certainly had some things to answer for. But there's this whole issue about, what in this particular case, it was a week. First of all, the guy had been fired. Okay. Mullinax had been fired. 7 days later, 7 days afterwards, the attack occurred. Now, here's a dilemma. The idea of liability in cases like this has a lot to do with control, okay? That once you fire an employee, there's no longer any control, okay? So basically, there's no respondeat superior here, that there's no real way to conduct post-termination control. In other words, there's just nothing they could do on that score. The other problem with respect to Wheaton, okay, had to do with Wheaton's connection to all this was really tenuous. Wheaton did not know, according to it, that Absolute De-Lux had put this ad in the Yellow Pages, linking them together and not explaining it, that they would only do interstate moves. And so if Absolute De-Lux was doing something other than an interstate move, they were not acting as an agent of Wheaton van lines. And so the problem is that the court basically found that Wheaton's involvement was so tenuous that you could not hold Wheaton liable. So what happened was the judgment for $1.3 million and the jury verdict connected to that was overturned. In other words, reversed by the Court of Appeals. Of course, as to Wheaton, because it was Wheaton that appealed. Okay, so what's the moral of this story? Goodness sakes alive, maybe if you got to move from one apartment to another, you might be better off getting some buddies and a couple of 6-packs of beer. Another thing is that if you're going to do a move, this weird ass case, indicates you ought to get some confirmation that they are, are they background checking their employees, this sort of thing, because it involves people coming into your residence and handling your property and things like that, and get some written assurance. Because if they're not truthful, they're definitely violating a provision, a consumer law provision, okay? So that's it, the story of the Absolute De-Lux ass whipping. Tom Swanson signing off. Have a good day. Be careful who you hire as a mover.